Welcome to Low Cost CLE. This recorded continuing legal education course is one of a series that will be produced by Low Cost CLE. Please review our webpage for upcoming live and recorded courses. My name is Scott Peterson, and I will be your web narrator for today's presentation. This presentation is web-based with initial production in Toronto, Canada. I previously practiced law in Washington and Arizona. Currently, I am a professional actor based in Seattle, Washington. You can see me in the upcoming film Laggies, starring Keira Knightley. While practicing law, I had numerous landlord-tenant appeals heard in Division I of the Court of Appeals. Our primary audience for today's CLE is United States attorneys. However, my barrister and solicitor friends in both Australia and New Zealand should find this both interesting and informing, as the United States landlord-tenant law is primarily based upon common law with statutory changes that override the common law. Further, it may be beneficial for landlords. My goal today in this course is first to ensure that you understand the significance of proper preparation and proper service of a statutory notice for unlawful detainer. We also would like to help you prepare proper notices. Further, we would like you to understand the common pitfalls that a practitioner may run into. To assist in doing this, we'll not only look at the proper preparation of notices, but also we will look at some notices that were improperly prepared, and you can see how that will affect any eviction matter. Throughout this CLE and all other low-cost CLE presentations, we will use consistent symbols. The green light indicates case law or statutes that the courts will follow. The stop sign indicates questionable case law. Many times various courts continue to follow questionable case law, so it is important to be aware of case law that may be followed in some jurisdictions. The light bulb indicates a case or statutory analysis. Hopefully the light will come on in your head when you hear the analysis, especially if you disagree with our analysis. Finally, the red exclamation point indicates a practice pointer. So, the first thing we must ask is, why is a statutory notice required? Notice and an opportunity to be heard is required under the United States Constitution, 14th Amendment. The 14th Amendment applies to state and local governments, but not to individuals. So, why must an individual landlord give notice to a tenant prior to an eviction? Well, because a civil suit is necessary to evict the tenant, and because this will be administered through the state court system, and because a physical eviction will be carried out by the county sheriff, a state action is involved. Article 1, Section 2 of the Washington Constitution states that the Constitution of the United States is the supreme law of the land. Article 1, Section 3 states that no person shall be deprived of life, liberty, or property without due process of law. This text is identical to the United States Constitution, 5th Amendment, which also states that no person shall be deprived of life, liberty, or property without due process of law. Further, the United States Constitution, 14th Amendment, Section 1, states that nor shall any state deprive any person of life, liberty, or property without due process of law. Judge Henry Friendly wrote in an article that remains highly influential, entitled Some Kind of Hearing, that these due process rights apply equally in civil and criminal matters. These due process rights, and there are 10 of them, will be gone over briefly, but I want to note that one of them is notice. First, there must be an unbiased tribunal. Second, the subject of the CLE, which is notice of the proposed action and the grounds asserted for it. Number 3 is the opportunity to present reasons why the proposed action should not take place. 4, the right to present evidence, including calling witnesses. 5th, the right to know opposing evidence. 6th, the right to cross-examine adverse witnesses. 7, a decision based exclusively on the evidence presented. 8, the opportunity to be represented by counsel. 9, the requirement that the tribunal prepare a written record of the evidence presented. And finally, the requirement that the tribunal prepare written findings of fact and reasons for its decisions. In conclusion, a notice is required under the state and federal constitutions. RCW 59.12 and 030 and .040 ensure that the eviction procedures in Washington comply with the dictates of the state and federal constitutions. RCW 59.12.030 describes the appropriate notices, and RCW 59.12.040 describes how to serve these notices. I do want to make one correction to what I just said, and that is the ninth reason, or the ninth factor in whether or not you receive due process, and that is it's a requirement that the tribunal prepare a record of the evidence presented. It need not be written, they just must prepare a record. Housing Authority v. Terry, or some case that follows this principle, is cited in every landlord-tenant case in the Court of Appeals or Supreme Court. Because the landlord-tenant statutes are in derogation of common law, they are interpreted strictly in favor of the tenants. Unfortunately, this principle is rarely utilized by court commissioners in some counties. Typically, it is cited by the appellate courts to show that any ambiguities in the law will be interpreted in favor of the tenant. Rarely will a trial court acknowledge this legal principle. Another case that has frequently been cited in the appellate courts is Sowers v. Lewis. This case stands for the proposition that service of a proper notice is a jurisdictional prerequisite to commencement of an unlawful detainer action. As we will discuss below, in the cases of Bin and Pryor, it appears that Sowers v. Lewis has been overruled and that Bin and Pryor will be cited in the future for the proposition that our state constitution conveys jurisdiction in unlawful detainer actions, and that subject matter jurisdiction is no longer obtained only after proper service of a proper statutory notice. While Housing Authority v. Terry is often cited for the proposition that statutes must be strictly interpreted in favor of the tenant, it is also often cited for the proposition that proper notice is a jurisdictional condition precedent to an unlawful detainer action. There are two types of jurisdiction. First, there is personal jurisdiction. Personal jurisdiction is conveyed by properly serving the defendant. Second, there is subject matter jurisdiction. Subject matter jurisdiction deals with the authority of the court to hear the matter. For example, you cannot bring an unlawful detainer action in federal bankruptcy court, as that court's jurisdiction is limited to bankruptcies. Similarly, you cannot bring an unlawful detainer action in small claims court or district court, because under Washington's Constitution, jurisdiction is exclusively vested in the superior court where the property is located. Again, as we will discuss later, Bin and Pryor appear to overrule this often cited proposition. Another often cited case is Sullivan v. Purvis. This case states that improper notice deprives the court of unlawful detainer jurisdiction. Again, this has probably been overruled. This case also stands for the proposition that the parties cannot stipulate to jurisdiction. But beware of the practice pointer in the next slide. Addressing jurisdiction, be specific. It is subject matter jurisdiction or personal jurisdiction. When you are in front of a court commissioner, they are very busy because they serve as the screening function of the trial courts. Often the court wants to rush through your matter without thorough attention to the details. This is wrong. You must preserve the record. Always refer to the jurisdiction in terms of subject matter jurisdiction or personal jurisdiction. When you're at a restaurant, you get something different when you order a burger as opposed to when you order a cheeseburger or a bacon burger. Unfortunately, while a court commissioner may not inquire as to whether you mean personal or subject matter jurisdiction, a wait person will always inquire as to what type of burger you are requesting. With that said, I believe the ethical rules prohibit me from answering who is smarter, wait staff or court commissioners. To the two cases that I discussed previously, Housing Authority v. Bin and HHM&F LLC v. Pryor. The Bin case discusses that jurisdiction is conferred in an unlawful detainer action by the state constitution. It further states that a party who files an action after improper notice may not maintain such action, and it may not avail itself of the superior court's jurisdiction. The prior matter states that an unlawful detainer action is within the superior court's jurisdiction. Thus, any defects or errors go to something other than subject matter jurisdiction. These two cases appear to overrule the case of Truly v. Huft. In Truly v. Huft, the Court of Appeals stated that when a summons did not correctly state the methods that a tenant had to respond to that summons, that the court lacked subject matter jurisdiction because of improper service. However, the prior ruling from Truly v. Huft was a double-edged sword because, yes, the courts had held that there was not subject matter jurisdiction, thus the judgment was void. The problem there was that the courts were also interpreting that to mean that attorney's fees were not available. Also, unfortunately, the court commissioners did not necessarily understand the decision, and they did not believe that attorney's fees were available in a situation where the lease agreement allowed attorney's fees. So when you discuss the double-edged sword, under current case law, the court does have subject matter jurisdiction, and if there's a basis for attorney's fees, then those can be awarded. The court commissioners can no longer use the excuse that they have the only jurisdiction they have, or the only authority that they have, is to dismiss the action. Now the court can, under Bin and Pryor, can dismiss the action and then award attorney's fees to the prevailing party, which would be the tenant. While older case law indicates that proper service of a proper notice is a condition precedent to the court obtaining jurisdiction, and newer case law indicates that jurisdiction is conferred merely by filing the action in the superior court where the property is located, the wise practitioner will not proceed without proper service of a proper notice. In a review of appellate cases in the past 10 years or so involving notice issues, it becomes readily apparent that it is a minor error that could have been corrected at the initial stages that was made by the landlord that led to the decision. Very often they were decisions where there were a large dollar amount in attorney's fees that were awarded. In one unpublished case, that caused quite the commotion in the landlord-tenant circles, and that is Culpepper v. Jordan. There was improper service of the statutory notice. That, of course, went to the Court of Appeals, and approximately $15,000 later in attorney's fees, a ruling was made in favor of the tenant. Now that matter could have been averted if the landlord had only spent 46 cents and mailed a copy of the notice to the wife. What happened in Culpepper v. Jordan was that the landlord personally served a notice, a 3-day notice for non-payment of rent on the husband. Meanwhile, the wife was inside the house, and she started walking towards the vehicle where the landlord and her husband were standing. And prior to her arrival, the landlord walked away, and the landlord stated that he observed the husband showing a copy of the statutory notice to the wife. The trial court in that matter ruled that that was proper service. However, the Court of Appeals stated that it was not proper service. As previously stated, this problem could have been easily averted. First, the landlord could have just waited until the wife walked the additional 10 feet and handed her a copy. Second, he could have handed 2 copies to the husband and then mailed the copy to the wife at that address, which goes back to what I said at the beginning, which is that but for a 48-cent stamp, the court would have had jurisdiction in that matter. Now, under the newer case law, it's no longer referred to as jurisdiction, but the court could not have proceeded forward even under the new rules based on that proposition. Now that we have discussed the case law surrounding notices and whether jurisdiction is conveyed by proper service of a proper notice, I hope that I have impressed upon you the importance of a proper notice and proper service of that notice. This is easier said than done because often the landlord prepares a statutory notice. But as an attorney, you must ensure that the notices are proper and that they are properly prepared and served if it was done improperly the first time. While your client may get upset at having to pay you to redo the statutory notice, it's much tougher explaining to the landlord why the unlawful detainer action was thrown out after the landlord incurred $1,000 in legal fees and costs. With that said, it brings us to the statutes affecting unlawful detainer notices. First, for Seattle only, there is the Just Cause Eviction Ordinance. The Seattle Just Cause Eviction Ordinance specifies the only reasons a tenancy can be terminated. It also requires the landlord to disclose the reasons for terminating the tenancy. The next few slides will show all of the reasons a tenancy can be terminated. However, we will only discuss the important reasons. While Seattle's Just Cause Eviction Ordinance requires the reason for termination of the tenancy to be stated in the statutory notice, this practice should not be followed in other jurisdictions. Yes, you must specify a basic reason for a statutory notice, for example, non-payment of rent. However, do not go further than required. If you prepare a 20-day notice to terminate the tenancy, do not go into great depth as to why. Outside Seattle, the easiest method to terminate a tenancy is through a 20-day notice to terminate, which can be prepared for any reason. But if you explain in the 20-day notice or in a conversation with the tenant why you are evicting the tenant, you open up a potential show cause hearing issue as to whether the reason for the termination is appropriate. The only time a landlord really loses an unlawful detainer action is if the matter goes from the show cause hearing to a full trial, because there is a material issue of fact. With no reason given for the notice to terminate a tenancy, at a show cause hearing, the attorney can object to any questions as to why the notice was issued because no reason is required. But if the landlord ever gives an inappropriate reason, this could become an issue. The most common reason you will seek to terminate a tenancy is for non-payment of rent. Further, one of the most common reasons that a landlord loses at a show cause hearing is that, without advising the attorney, the landlord accepts full or partial payment of the rent. For some reason, this seems like common sense to an attorney, but it doesn't appear to be common sense to a landlord. Because it seems like such common sense not to accept rent, often the attorney never advises the landlord not to accept the rent, unless the landlord does not want to proceed forward with the unlawful detainer action. Further, the attorney often never inquires of the landlord before a show cause hearing as to whether the landlord has accepted rent after service of the statutory notice. In the courtroom, it's very easy to determine the attorneys that make this mistake by the gasp heard from the attorney when the court commissioner, often sua sponte, dismisses the action as partial or full rent payment has been accepted. My next comment is a practice pointer. Often a landlord wants to evict the tenant for reasons other than non-payment of rent, perhaps loud parties, domestic violence issues, or just general dissatisfaction with the tenant. If this is the case, make sure all parties involved know not to accept partial rent payments and not to accept any payment after the statutory notice period expires. I remember one complex that I represented had a very bad tenant that was on a long-term lease. The landlord could not terminate the lease, and the evidence to support a 10-day notice was going to be difficult to obtain, as none of the neighbors would be willing to testify as they were afraid of the tenants. But the landlord forgot to inform all of the employees not to accept rent after the notice period expired. So, once months of trying to figure out a way to terminate the tenancy were resolved because the tenant failed to pay the rent, and once the return date on the summons for unlawful detainer had expired, but before a default judgment was obtained, an employee mistakenly accepted rent from the tenant. This is a mistake the landlord typically makes only once, and after that procedures such as red flagging the file or daily employee briefings, those procedures are instituted, or new procedures are instituted to avoid a repeat of this mistake. Habitual lateness is also the basis for terminating a tenancy. However, if you intend to use this approach, do not allow the tenant to claim an estoppel issue because you do not initiate action when the tenant has been late 4 times in the prior 12 months, the number of times before a tenant can be evicted for habitual lateness in rent payment. While the statute says 4 or more, a recent court decision has determined that the landlord cannot proceed in an unlawful detainer action based upon habitual lateness when the tenant has previously been late with the rent and an action was not initiated based upon habitual lateness. 2 other reasons are material non-compliance with a lease term, habitual material non-compliance, and habitual non-compliance requires 3 times in a 12-month period for the tenant to be late. Other reasons to terminate a tenancy are when the tenant causes severe property damage, creates a nuisance, or engages in criminal activity. Also, if the landlord wants the unit to be occupied by an immediate family member, or if the landlord resides in the same unit as the tenant, the landlord can also terminate a tenancy in Seattle. Occupancy by a family member as a justification for an eviction is one of the most abused provisions by landlords of the ordinance. It is a good idea to advise your client that a family member must legitimately move in, even if you don't suspect that this is what the landlord intends to do. Further, if for some reason the family member does not move in, it is wise that the reasons be fully documented, as there could be future litigation revolving around that issue. The justifications for terminating a tenancy shown on this slide are self-explanatory. Again, the reasons on this slide to terminate a tenancy are self-explanatory. The first one, selling a single-family residence, applies only to single-family residences, not to apartment complexes. We now move on to the various statutes under the Revised Code of Washington that apply to notices and unlawful detainer actions. RCW 59.12.030 defines a tenant for less than life as being in unlawful detainer when the tenant commits an act or does not comply with the notice served under subsections 1 through 7. The next 7 slides discuss subsections 1 through 7. The first method for a tenant to be in the status of unlawful detainer is when the tenant has a lease for a set period of time and holds over. Rarely is this type of lease seen, as typically a lease converts to month after an initial period. Having a lease for a set period of time could be an advantage in Seattle, as the just cause eviction ordinance would not apply. However, it would be incumbent upon both the landlord and tenant to sign a new lease prior to the expiration of each term, which could be a month, a quarter, or some similar time period. A tenant is also an unlawful detainer if the tenant does not vacate the premise after receipt of a 20-day notice to terminate the tenancy. However, this 20-day notice must be served 20 days prior to the end of the lease period. For example, the end of the month, or if the 15th of the month is the end of the lease period, 20 days prior to the 15th of the month. An excellent case discussing a 20-day notice that was served more than 20 days prior to the end of the month, but not 20 days prior to the end of the lease period claimed by the tenant is Leda v. Wisnand. This case is better known for the proposition that at a show cause hearing the court must examine the parties and witnesses, and that only competent evidence is admissible. In Wisnand, the tenant asked the court in at least 3 different ways to allow testimony from the tenant. The court refused to take testimony, but would only allow an offer of proof. When the tenant made an offer of proof, for some reason the court disallowed the testimony. But this disallowed testimony was the only competent evidence introduced, along with the answer by the tenant, that purported and supported the proposition that the lease period was other than the end of the month. Under RCW 59.12.030, paragraph 3, the tenant is in unlawful detainer if the tenant fails to vacate 3 days after service of a notice to pay rent or vacate the premise. This is the most common type of an eviction. There are many pitfalls facing the attorney or landlord in this type of eviction action. First, the notice can be served at any time after the rent becomes due. But what happens if the lease agreement says that the rent is due on the 1st of the month and it's late on the 5th? This is a typical scenario, as a common form of lease agreement uses this wording. Under this scenario, if the tenant failed to pay rent on the 1st, and if the 3-day notice was personally served on the 2nd, the tenant would have until the 5th day, or the 5th of the month, to pay the rent under the notice. For example, day 1 is the 3rd, day 2 is the 4th, and day 3 is the 5th. There do not appear to be any problems under this scenario. But what if there are multiple tenants? Rarely will a landlord be able to serve multiple tenants, each of them being served personally. Under this scenario, you would need to allow the tenant 4 days to pay the rent. The subject of mailing the notices will be discussed further under RCW 59.12.040. So here, the tenants would have through the 6th to pay the rent, while your landlord client can take the aggressive approach and serve 3-day notices starting on the 2nd. It appears that a better approach would be to allow the tenant the full time period through the 5th to pay the rent and then begin serving the 3-day notices. In light of the number of different court commissioners and the varying interpretations that these commissioners apply, along with the always present possibility of a pro tem commissioner, it appears best to take the conservative approach and not serve a 3-day notice until the time period to pay the rent has expired. While I mentioned the possibility of an unusual decision by a pro tem commissioner, another wild card is a Superior Court judge on the ex parte calendar. Two unusual circumstances related to having a judge run the ex parte courtroom is that the judge doesn't always have experience in the many types of cases heard ex parte, for example, adoption, probate, unlawful detainer. First, a judge is familiar with the briefing of the issues prior to making a decision. In the ex parte courtroom, all the issues are not briefed, and an instant decision is expected of the judge. There was a matter once on the ex parte calendar with a judge presiding. The judge made an obviously wrong decision. The attorney looked over at the clerk of the court in amazement, and the judge looked at the clerk of the court, wondering why the attorney was no longer looking at the judge. And the clerk then nodded to the judge that she should sign the paperwork, and the judge did, saying, "On second thought, I will sign that order." Amazingly, the clerk of the courtroom probably does know more about the ex parte courtroom procedures than a judge. Another pitfall in unlawful detainer notices is judicial interpretation of notice requirements. As previously discussed, in the unpublished case of Culpepper v. Jordan, the judge wrongfully interpreted the statute to allow service upon one tenant to constitute service on all tenants. Another surprising scenario with pro tem commissioners involved a landlord who did serve a proper notice. At the show cause hearing, the commissioner threw out the unlawful detainer action, stating that the tenant had complied with the statutory notice. The factual scenario was that the tenant claimed that very late on the night of the 3rd day after service of the notice, he took the rent payment to the landlord's house, but because it was so late, he put the payment under the doormat, and the payment was in cash. The tenant then stated that after he was served with a summons and complaint, despite having paid the rent, that he went to the landlord's house. At the landlord's house, the tenant discovered that the cash was still under the doormat. It was only then that the tenant realized that he had put the money under the doormat at the wrong house. Now, if you believe that a tenant left cash under a doormat of the wrong house, and it was still there 1 week later when the tenant went back to the house, well, let me put it this way. I have some land for sale in Florida. Please give me a call. And now another practice pointer. You've probably been hearing this since the day you graduated from law school. Your client can control the outcome of every legal matter. You always have the option of settling the matter. This is where you need to assert control over the case from day one. This doesn't mean that you tell the client what to do. Instead, it means making sure that the client understands that on any given day the court can, and does, make a costly wrongful decision. If the landlord wants control of the case, this may mean settlement. It's amazing that sometimes a landlord is willing to take a matter to a show cause hearing when all the tenant wants is a few days to vacate the property, or perhaps the tenant just doesn't want to incur attorney's fees. Is it really worth the risk and expense of a show cause hearing when the matter can be settled through a stipulation? One only need to look at the smile on a court commissioner's face when they call your matter and you ask the commissioner to sign an agreed stipulation. Commissioners love to have the unlawful detainer matters on the show cause hearing calendar settled. So, now let's get back to notices. A 10-day notice to comply with the lease condition is another notice. This notice often seems to be the best friend of the landlord and the evil enemy of the eviction attorney. Why? The landlord always believes it will be easy to prove that the tenant violated the lease. But, as an attorney soon discovers, perhaps the landlord claims that the tenant now has a pet contrary to the lease, and the tenant says that he only took the dog in because it was wandering the street that day. Or the landlord will claim that the tenant is disturbing the neighbors through loud parties, and the tenant stops having parties for the next couple of weeks before starting the parties again. Worse yet, the landlord often believes that the other tenants will testify for the landlord. But when it comes time for the testimony, the other tenant must work that day. The other tenant is suddenly afraid of testifying in the case in the event that the tenant is allowed to stay, or the tenant changes his story. While the landlord has a vested interest in evicting the tenant and in keeping his version of the story consistent, the other tenants have no such vested interest. If the other tenant who was once willing to testify, but suddenly he becomes unavailable or uncooperative, the landlord may lose the case and incur legal fees and costs. The reluctant other tenant loses nothing by refusing to testify or by changing his story. While it may be necessary at times to serve and follow through on a 10-day notice, it's certainly worthwhile to give consideration and to give much thought to using a 3-day notice for non-payment of rent, or perhaps a 20-day notice to terminate the tenancy. Both of these notices give much more certainty to the landlord. A good practice pointer on a 10-day notice to terminate a tenancy based upon a lease violation is to both 1. Cite the lease provision that the tenant violated, and 2. Attach a copy of the lease to the 10-day notice. There are many reasons why this is a good practice. First, you can double check to make sure that the claimed provision is actually in the lease if you're attaching it to the notice, and therefore you have a copy there to review. Second, the tenant can see an actual text of the lease, not just a summary. And third, there can be no question as to what is required for compliance with the lease. Fourth and finally, with limited opportunities to make an appellate record, including the lease with the notice helps establish that there was a lease and that the lease attached to the notice is authentic, especially if the tenant never objects to the attached lease, or if the tenant never states that it's not a true and correct copy of the lease. RCW 59.12.0305 is commonly known as a waste or nuisance notice. Again, while the landlords very often like to use this type of notice, it causes some evidentiary problems for an attorney. And again, a better practice would be to see if it's possible to serve a 3-day notice to terminate a tenancy, or to issue a 20-day notice to terminate the tenancy. RCW 59.12.030 Section 6 is a type of notice that is rarely used. It's for when a person moves on the property without permission, or when a person refuses to leave the property after being ordered to do so. It's important to distinguish between the scenario that Section 6 refers to and the situation of somebody who arrives on the property after the statutory notice is served. So, for example, if you serve a 3-day notice for non-payment of rent and the tenant does not pay the rent, and then the tenant vacates, but he has some people that have either moved onto the property after the notice was served or that resided in the property at the time the notice was served, you don't need to serve a notice under subsection 6 because the people are not on the lease. Instead, under the statute, the notice is effective and the unlawful detainer action is effective for any tenant that comes onto the property after the date of service of the notice. A tenancy can also be terminated for gang-related activity. Here again, this provides evidentiary problems for the attorney, but on occasion a landlord does want to use this avenue to evict the tenant. Again, it might be better to see if you could terminate the tenancy based on non-payment of rent, a 3-day notice, or just by terminating the tenancy, which would be a 20-day notice. While for most unlawful detainer actions a statutory notice is required, in certain evictions under Washington's Residential Landlord-Tenant Act, there is no notice required prior to commencement of the unlawful detainer action. Now, this is only under the Residential Landlord-Tenant Act, RCW 59.18, not under the Washington's Landlord-Tenant Act, which is RCW 59.12. And these circumstances where notice is not required under RCW 59.18 would be for drug activity, for gang activity, for an imminent hazard, or for an assault on the premise or using a firearm or deadly weapon. Additionally, there's no notice necessary for an eviction after a foreclosure. However, an eviction after a foreclosure would be proceeded upon based upon the procedures in RCW 59.12. When preparing notices, there are many legal concerns that an attorney should have. First, preparation of a notice for collection of past due rent may invite attorney liability under the Fair Debt Collection Practices Act. Numerous Washington attorneys have been defendants in federal actions because they did not provide proper warnings or notices to debtors, or they have charged fees not authorized by the statute, or they have improperly misled a tenant on the various avenues to respond to a summons. Some law firms have also been defendants in class actions. These law firms are some of the largest unlawful detainer firms in the state. Second, there is questionable case law concerning whether ancillary charges, such as late fees, can be included in a 3-day notice under RCW 59.12.030, paragraph 3. As you will recall, a 3-day notice under this section is for non-payment of rent. While some lease agreements specifically designate late charges as rent, most do not. Now, I don't know if you were like me when you took civil procedure in law school, but I always wondered, why did the attorney wait until the last day before the statute of limitations expired to serve a complaint? In this situation, I wonder, why does an attorney include these late fees when it's really not necessary to include that to proceed forward with the action? The main service an unlawful detainer attorney provides is getting the tenant out of the property. Third, advise your client not to accept partial payments or full payments without notifying you. Well, the landlord is required to accept full payment after service of a 3-day notice for non-payment of rent. At any other time, if the landlord accepts rent, you need to know so that you can dismiss the action. We went over this earlier, but the reason I'm going over it again is that this is a critical issue that often catches an attorney by surprise. Fourth, serving new notices may invalidate prior served notices. While the law may not be clear, the court commissioners are clear. This confuses the tenants. If you serve a 3-day notice for rent and the 3-day notice waiting period expires, don't serve any other notices. Typically these notices say something like, comply or your tenancy will be terminated. You can see how a tenant could be confused if he already thought that the tenancy was terminated after he failed to pay the rent, but then he gets a new notice stating that it will be terminated if he does not comply with a new condition. Or if the tenant doesn't pay the rent and believes that he can stay in the premise by complying with the corrective actions detailed in a 10-day notice. A good warning used by some attorneys states that a tenant must comply with each individual notice, and compliance with one notice still requires compliance with the other notices to maintain the tenancy. Whether you represent landlords or tenants, or perhaps you are a landlord or a tenant, this is a very important section. While tenants' attorneys often believe that they are more competent to review a statutory notice for errors, a landlord's attorney actually does this more often. Very often, a landlord prepares a notice for use by the attorney. This is interesting because the most critical action in an unlawful detainer action is the proper preparation and proper service of the statutory notice. So, a landlord performs the most critical step by himself and lets the attorney perform the portions of the unlawful detainer action that can be at best described as a forms practice that does not take great legal abilities, just the ability to complete the blanks in the law firm's forms. Where attorneys run into problems is when they try to find a way to proceed forward with an improperly prepared or improperly served statutory notice. Very often the landlord is upset at having to pay for having to pay an attorney to evict the tenant. Paying an attorney to properly prepare and serve a statutory notice, a function that the landlord believes is simple to perform, will upset the landlord-client who does not recognize the importance of proper notice. After viewing this CLE and the materials previously presented, nobody listening to this CLE should believe that the notices are a simple part of an unlawful detainer action. But even if you keep your notice pricing low, a landlord typically believes that they can prepare and serve the notice properly. The first step in reviewing a statutory notice is to compare the notice to the lease agreement. Sometimes you can quickly review the provision headings and quickly review the lease, but do this at your own risk. Sometimes the critical portions of a lease are hidden away under a heading where you would not expect the topic to be addressed. The second step is to reread the applicable portion of the lease as you compare it to the statutory notice provisions or conditions. The third step is to review each and every element of the statutory notice. You need to make sure that the address is correct, the names of the tenant or tenants are correct, and that every element completed in the form, or perhaps every element of a form that is purchased from some source or that was created by the landlord. Make sure you review the entire notice to make sure that everything has been done correctly. Now, I really quickly went over the importance of reviewing the lease agreement prior to preparing a statutory notice. Interestingly, In the case of IBF LLC v. Huft, and Huft is spelled H-E-U-F-T, in that case, the court commissioner refused to review the lease agreement and refused to review the statutes concerning notices. Had the commissioner reviewed the lease agreement prior to making her decision, she would have realized that while the landlord brought the action based upon a 20-day notice that was served approximately the 10th of the month and was effective at the end of the month, in actuality, the lease agreement required a 30-day notice. And in that situation, the lease agreement trumps the statute, and the tenant is afforded the longer notice period as agreed to in the lease. Had this commissioner attended this CLE course, and then had she reviewed the lease agreement prior to making her decision, the matter would not have been reversed by the Court of Appeals, and the tenant would have been able to stay in the premise, not be wrongfully evicted, and the landlord would not be subjected to a wrongful eviction lawsuit subsequently. There are three methods to serve a statutory notice prior to initiating an unlawful detainer action. We will now go over those three methods and the order that they must be done in, and how to properly analyze the service methods and processes. Under RCW 59.12.040, the first method of service of a statutory notice is personal service upon the tenant. While this may seem like a simple method to serve a tenant, amazingly, landlords, attorneys, and judges commonly make mistakes involving personal service. Before I go into a case discussing personal service, it is important to note that the tenant can be served anywhere if there is only one tenant. The problem here, as in service of a summons in a civil matter, is that by attempting service at any place other than the person's home, you cannot serve the statutory notice through substituted service on the other tenants. Interestingly, the tenant can also be served by the landlord, unlike service of summons that must be served by somebody other than a party to the action. In an unpublished case that caused needless strife in the unlawful detainer circles, the Court of Appeals held that personal service of a husband in the presence of his wife did not constitute personal service upon the wife. The case name was Culpepper v. Jordan. The facts in this case were that the landlord attempted to personally serve the tenants with a 3-day notice to pay rent. The landlord encountered the husband in the driveway, spoke to the husband for quite a while, and handed him one copy of a 3-day notice. The wife was in the house. As the landlord started walking away, the wife walked up to the husband. The landlord noted that the husband showed the wife the statutory notice that he had previously handed to the husband. A fact known to the trial court judge, but not to the Court of Appeals, was that the tenant wife had undergone a mastectomy 1 week before the trial. While one would think that under these circumstances the judge would carefully weigh any decision so as to not needlessly and improperly put the woman and her children out on the street, the judge ignored over 100 years of case law. In 2 hearings before a Snohomish County Commissioner, and both a motion to the judge before the trial began and in closing arguments, the tenants argued that service of the statutory notice was improper and that the trial court did not have subject matter jurisdiction. At that time, case law dictated that proper service of a proper notice was a condition precedent to the trial court having jurisdiction in an unlawful detainer action. Of course, now, with the case of Housing Authority of the City of Seattle v. Bin, the current line of cases dictates that jurisdiction is conveyed by the Washington State Constitution, not by proper service of a statutory notice. The citation for Bin is 163 Wash App 367. However, while it appears that jurisdiction is no longer conveyed through proper service of a statutory notice, the case of Christensen v. Ellsworth is enlightening. The citation for Ellsworth is 162 Washington 2nd 365 or 173 Pacific 3rd 228, and the case is from 2007. In Christensen, the court held that the deadline time period for a statutory notice is a waiting period before which an action for unlawful detainer cannot be commenced. So, now back to Culpepper. Even if Culpepper were heard today, one could argue that because a statutory notice was not properly served, the waiting period never commenced, and thus the matter was improperly initiated, and it should be dismissed. In fact, in the Christensen case, the court noted that a tenant is guilty of unlawful detainer once the deadline imposed by the statutory notice expires. Further, a tenant must be guilty of unlawful detainer before an unlawful detainer action can be commenced. Thus, it appears that while the trial court acquires jurisdiction merely by the filing of an unlawful detainer in the action in the county where the property is located, that unlawful detainer action is prematurely initiated if the tenant is not guilty of unlawful detainer prior to the action being filed. Thus, if the action is filed before the statutory waiting period expires, or if the waiting period never begins because the service is improper, the courts now will most likely dismiss the action as being prematurely filed. Further, because you cannot file a prospective unlawful detainer action based upon the belief that the tenant may become an unlawful detainer and not comply with the statutory notice, it is unlikely that the courts would allow a landlord to file an unlawful detainer action and then later serve the statutory notice properly. I mentioned that Culpepper v. Jordan caused needless strife in legal communities. The reason that the strife was needless is that Culpepper provided clarity in unlawful detainer actions. Years ago, criminal attorney John Rongerud gave me enlightening advice after his client that was a tenant prevailed in a legal matter. John said that while his client won the case, overall, landlords won because the case created certainty. Landlords like certainty. Tenants like uncertainty and gray areas, which can delay the unlawful detainer procedures. With that said, various landlord organizations sought legislatively to have the results of Culpepper v. Jordan overruled by legislation, and these attempts were misguided. Culpepper provided certainty for landlords. Culpepper also provided a good roadmap for service of unlawful detainer actions and the notices in those actions. So, after all of this, personal service means personal service. If you serve the husband, that is not service on his wife. What Culpepper should have done was serve one copy of the notice on the husband and then tried to hand a copy of that notice to the wife. If he could not hand a copy to the wife, he should have given 2 copies to the husband. This action, plus additional steps detailed later, would have been adequate service. Now, if personal service is obtained on the only tenant, you have completed proper service. If you are unable to serve all tenants, or if you only serve one of many tenants, you must follow the steps from one of the other 2 methods of serving a notice. Only after you have unsuccessfully attempted personal service, can you attempt service through service on some person of suitable age and discretion? With a quick glance at this section, you immediately think that this is similar to substituted service under the civil rules. Yes, the person must be of suitable age and discretion, but note that under this statute, the person need not reside on the premise. While I cannot get into the head of the person that drafted this provision, it is likely that somebody other than a resident can be served, because the second part of this rule requires that in addition to leaving the notice with a person at the residence, you must also mail a copy of the notice. To the best of my knowledge, there has never been a precedential case that discusses this issue and eliminates certain classes of persons, such as a babysitter. Also, note that this section states that this provision for service can only be used if the tenant is absent from the premises unlawfully held. This indicates that if a husband and wife or roommates are both at the house, you must attempt personal service on both. There is a good possibility once the type of notice is seen that the spouse or roommate will not attempt to get the other person into the room for service. So if this happens, it should qualify as substituted service because you did attempt to get the person named on the notice into the room. Interestingly, there is a problem with this statute. The statute indicates that service can be made through another person if the tenant is absent from the premises unlawfully held. The problem here is that there is no unlawfully held premises at this time. The tenant only becomes guilty of unlawful detainer once the notice period has expired. So, once you have attempted personal service and been unsuccessful, and once you have attempted to serve somebody else on the premise and been unsuccessful, you can then serve the tenant through the third method. A pro se landlord, and sometimes attorneys, view the statute on service of statutory notices to allow three alternative methods of service, and that the landlord or process server can determine the appropriate method of service that is used. In fact, you must unsuccessfully attempt method 1, personal service, before you can attempt method 2, substituted service. And you must attempt both methods 1 and 2, personal service and substituted service, before you can complete service by method 3, which is commonly called posting and mailing. Specifically, method 3 allows the landlord to affix a copy of the notice in a conspicuous place. This conspicuous place is commonly obtained by taping a copy of the notice to the front door. If you cannot access the front door, there are some other good suggestions. However, make sure that the reason that you cannot access the front door is something you can control, such as forgetting to give the server a key to a locked building. Taping a copy of the notice to the front door of the building is probably not adequate in a circumstance where you merely lack a key to the building to get to the front door of the tenant. Other alternatives to taping the notice to the front door may be necessary if the property is locked and gated, or if there are dangerous animals on the property. A good practice tip is for the process server to take a photograph of the house from the street and have that photograph include the front door. And then, after attempting the first two methods of service and determining that a notice needs to be taped to the door, to take a close-up picture of the front door with the notice after service. And it's also handy to have the date and timestamp on that photograph.
If you post to other than the front door, make sure to take a picture of where the notice was posted so that it'll make it easier for the court to determine if that posting is prominent. The other requirement is that the notice must be mailed if you are posting the notice. It must be mailed in the county where the property is located. As a practical matter, this would only be a factor on evictions near a county line. As a tenant, this would be a difficult defense to assert. First, with cutbacks in the U.S. Postal Service, most mail is moved from the pickup point to a central processing area. A notice could be mailed in Snohomish or Pierce counties, but postmarked in Seattle, which is King County. Further, the courts are not receptive to this argument. One commissioner in Snohomish County noted that in the matter, although the process server did not indicate that the notice was mailed within Snohomish County, with the location of the property, but the commissioner noted that because the property was located in Snohomish, and that because the process server's address was in Snohomish County, that this proves that the notice was mailed in Snohomish County. If anybody can figure out logically why this conclusion follows the facts, please let me know. It's beyond me. It would have been much easier if the process server included in the declaration the name of the county where the notice was mailed. Finally, if you serve the statutory notice via posting and mailing, you must add 1 day to the date that commencement of an unlawful detainer action is allowed. Now for another practice pointer. I paused a few seconds for you to review this practice pointer. I'm sure that you're underwhelmed by this practice pointer, but there is a huge point to it. Does your client really want to pay you to correct problems with a statutory notice? Probably not. What are the cost savings to a landlord between serving a notice properly as compared to serving it improperly? Well, as was argued in Culpepper v. Jordan, but for the want of a 46-cent stamp and the price of 2 copies of the notice, the court would have had jurisdiction. In actuality, the cost difference is a few stamps, envelopes, and copies. Cost is nothing great compared to the hours of legal time necessary for argument when you try to resuscitate bad service. So, here is how to ensure proper service every time. First, get the signed original notice and make 2 copies for each tenant, or that is each tenant that is named in the notice. It really helps if the notice is signed in blue ink so that you always know which notice is the original. For each named tenant, complete the address on the envelope, insert a copy of the notice, attach a stamp, and mail that envelope in the same county as the property, and before you attempt service on the tenants. So I want to say that again. Make sure that the envelope is mailed in the same county, and mail it before you attempt to even serve the tenants. The reason for this is if you ever called into court, or the process server is called into court and asked if they mailed a notice, we all know that they will say, yes, I did mail a copy, and they won't actually remember. But if the process server can say, yes, I mailed the notice, and I know that I mailed it because I always mail it before I even attempt personal service, that's much more credible and will carry much more weight with the court. The third step is go to the property and take a photo of the house from the street before attempting service. Fourth, once you've walked up to the house, knock on the door. If somebody answers, get their name and make a mental note of their description. hand that person one copy of the notice for each named tenant. The fifth step is, if there is no response after knocking, tape one copy of the notice to the door for each named tenant. Step back about 5 feet and get a photo of the door showing the notices affixed. The sixth step, once in a safe area, complete the declaration. It's not a good idea to step back, take a picture of the declaration or of the notice, and then take a photograph. This may cause needless distress if the tenant all of a sudden comes out there and wants to go after the person serving the notice, and would not be the first time that's happened. Now, it's helpful if you both name the person that was served on the document and have a description of them. If you really want to cover all bases, take a picture of the person that you hand the notice to with your cell phone. While this extra photograph may not seem important, I do have an actual case example where the photograph turned out to be handy. In that matter, a residential tenant was served at his work location. As stated above, the problem with, or previously in this CLE, the problem with serving a person at work is that the service is only effective upon that one person, not the other tenants. In this matter, when handing 2 copies of the notice to the tenant, or actually handing 1 copy of the notice to the tenant and 1 to his wife who is directly behind him, the process server secretly took a photograph through a camera. The tenant later, apparently, consulted with an attorney who advised that service at a business location was not effective service upon all tenants. In open court, the husband acknowledged receipt of the notice, but the wife and husband testified that the wife was not present at the work location when the notice was served, and that she was not properly served. There was a big problem with this assertion. The work location was a tattoo parlor. While the photograph was not very good, it did show a body in the foreground, which was the husband, and a forearm with a tattoo in the background. The tattoo in the background matched a tattoo plainly visible to the court commissioner on the wife's forearm. From that point on, the tenants had zero credibility with the court, and the landlord prevailed at the show cause hearing. With that said, we are now moving forward to a review of multiple problematic statutory notices before going over 3 statutory notices forms obtained off the internet from WashingtonEvictionAttorney.com. And our thanks go out to that webpage. Not that they allowed us to use them, but our thanks go to them because we stole them from that webpage. Whether you represent landlords or tenants, or perhaps you are a landlord or a tenant, this is a very important section. While tenant attorneys often believe that they are more competent to review a statutory notice for errors, a landlord attorney actually does this more often than a tenant's attorney. Very often, a landlord prepares a notice for use by the attorney. This is interesting because the most critical action in an unlawful detainer action is proper preparation and service of the statutory notice. So, a landlord performs the most critical step by himself and lets the attorney perform the portions of the unlawful detainer action that can be at best described as a forms practice that does not require any great legal abilities, just the abilities to complete the blank forms, or just the ability to complete the blanks in pre-prepared forms that the law firm has. Where attorneys run into problems is when they try to find a way to proceed forward with an improperly prepared notice or an improperly served statutory notice. Very often the landlord is upset at having the tenant that he must pay somebody to evict. Paying an attorney to properly prepare and serve a statutory notice, a function that the landlord believes is simple to perform, will upset that landlord client who does not recognize the importance of proper notice. After viewing the CLE and the materials previously presented, nobody listening to this CLE should believe that the notices are the simple part of an unlawful detainer action. But as an attorney, even if you keep your notice pricing low, a landlord typically believes that they can do it properly. When reviewing a statutory notice, you must compare the notice to the lease agreement and the applicable statute. Sometimes you can quickly review the provision headings and quickly review the lease, but do this at your own risk. Sometimes the critical portions of a lease are hidden away under a heading where you would not expect the topic to be addressed. You should also review each element of the actual served notice to make sure that the information is correct. Okay, so let's first review the 3-day notice in your packet with the name of Example 1, 3-day notice. I'm going to give you just a moment to review that document before I go into the problems with it. I hope this was enough time for you to review the entire notice contained in Example 1. If this is on the recorded version, just feel free to pause this to allow yourself more time to review the document prior to my going over it. So I'll give you just a second to pause it. Okay, if you're in the recorded session, I'm glad you're back, and if you're live, I'm sorry if I didn't allow you enough time. Now, the first problem I note here is that there's a blank line that says, this notice is in reference to the following described lease. While most of the time there is a written lease, and I believe that's what this paragraph refers to, there isn't always. In fact, there's a good possibility that in this eviction matter, there is only an oral lease. But something should be put in there. The second thing I noticed is that about a paragraph down it says, therefore, you are hereby given notice to immediately pay the amount of rent that is in default or to immediately vacate the property. The problem here is that under the statute, a tenant is allowed 3 days to pay the rent or vacate. Could be a 4th day if the notice was sent by mail. Further, By making a reference to a certain lease, there's always the possibility that that lease agreement allows more time than the statute allows to pay the rent. Very often you'll see a lease agreement that allows 10 days to pay the rent, and sometimes I've seen them up to 30 days, which really puts the landlord at a disadvantage because the tenant is automatically allowed to stay in the premise for 30 days without paying rent, and that's 30 days before you can serve notice. It doesn't include the time for the unlawful detainer action, but you could conceivably have a tenant living in the premise for 60 or more days before the sheriff would start the physical eviction proceedings. The next thing I notice, if you go down to the bottom right above the date line, it says, "This is not an eviction notice." Well, if it's not an eviction notice, what is it? I can't really answer that question, but I would not want to be in front of a court commissioner arguing that this is a statutory notice for non-payment of rent, when right in the notice I've said this is not an eviction notice. As an attorney or a landlord, if you are confronted with a notice such as this, you're going to have to use your discretion as to whether or not to proceed. My feeling would be it would be a lot simpler and a lot less costly to abandon this notice and start from scratch. All right, now please review example number 2. Example number 2 includes a 3-day notice, a note from the tenant to the landlord, or actually a note to the tenant from the landlord, and the court commissioner's ruling from the show cause hearing. I'll give you just a bit of time to review those documents prior to proceeding. Again, I hope you've had enough time to review the 3 documents in example number 2, the notice, the note from the landlord, and the court commissioner's ruling. From reviewing the notice, the first thing that I notice is that there are other charges on the 3-day notice. These include a late fee and a legal notice fee.
The court was never provided with a copy of the lease agreement, and that would be very helpful because you need to determine if late fees and a legal notice fee is allowed under the lease agreement. The second thing I notice here is that under the landlord's address there's a P.O. box. It's difficult to deliver funds to a P.O. box, and that could present problems. It would be a defense that the tenant could raise and say that, I wanted to pay on the fourth day. The fourth day was a Sunday, or it was late in the evening, and there was just no way to deliver the funds to a post office box. And the last thing I notice is there's no signature from the landlord. Now, years ago, Professor Peck from the University of Washington prepared several articles concerning the proper way to serve a notice or prepare a notice. One of his principles was the notice should be signed. However, if you look at the statute, there is no requirement for this, and I've rarely seen the courts follow any of the conditions that Professor Peck set out. The only time that I've even heard that mentioned was actually by a judge who had Professor Peck for her property professor when she was in law school, and while she did review the materials, she did not give much credence to the requirements that Professor Peck had, other than to note that he was her professor in college. The other thing that I noticed from this document, and I didn't catch it when I prepared the slide, but I'm noticing it right now, is that the document is dated July 16th of 2008. There is no signature on it, but if you look at the Declaration of Personal Service, it states that it was signed on July 17th of 2008. That presents a little bit of a problem because this document was prepared for service, and how can you have different dates? I don't think the court would buy that it was served on the 16th and ahead of time you prepared it under the belief that you would sign it the following day. It just doesn't make sense. I don't know what's going on here, but the actual day of service could be a material issue that would cause us to be set for a show cause hearing. Fortunately, there's a much bigger problem, which we'll get into next, which is a note from the landlord. So I'll now proceed to the note that the landlord delivered to the tenant. Okay, so right now we're reviewing example 2, the note from the landlord. If you notice, the date of this document is July 19th. The 3-day notice was dated the 16th. It was signed on the 17th, and this document is dated the 19th. This notice in the first paragraph refers to a few days ago. Apparently something was stated. But as you go further down through the notice, the landlord says that the court has upheld our decision to evict you. Well, the problem here is the action cannot be filed, or it's prematurely filed, if that waiting period has not expired. On a 3-day notice, there's a 3-day waiting period. If it was served on the 16th, as it appears from the notice, the 3 days would include the 17th, the 18th, and the 19th. So the earliest that the waiting period would have expired would have been at the beginning of the day, the 20th. But on the 19th,
the landlord sends that notice indicating that the court has upheld the decision. That, to me, that would indicate that the matter had been filed and they had had a hearing already. The next thing that I've noticed in this note to the tenant is that it indicates that they have communicated with the sheriff and they will be there within 10 days to see that you move out completely. The only communication that there would be with the sheriff would be if the court had issued a writ of restitution. So again, this indicates that a writ has, or that the court has ordered that the clerk issue a writ and that that has taken place. Now, another paragraph says, you may cure this illegal detainer by paying the amount in default by certified funds or cash. This is the only way we'll request the sheriff not to proceed. Please review the attached court orders. Obviously, there were no court orders, so there was nothing attached to the notice. Further, a tenant is not in the status of unlawful, not illegal, but they're not in the status of unlawful detainer until the notice period is expired, and on the 19th, if the notice was served on the 16th. On the 19th, the notice would not have expired, so the tenant was not in the status of unlawful detainer. It's also interesting to note that the landlord stated that the matter had been reported to credit bureaus and recorded in the county registers. Well, the only place you can really record something would be in the county recorder's office, and to the best of my knowledge, that was never done. Further, it is rare for a landlord to make a report directly to a credit reporting agency, so most likely that was never done. The next thing I note on the slide is that the contents are being held hostage for the rent. If you read the third paragraph, it says the sheriff will be moving them out within 10 days. If any of your personal belongings are left on the property when they arrive, we will have several individuals to help remove your possessions from the building and place them in storage for 30 days. After which, if you have not paid the total debt owed, we are allowed by law to dispose of the property and recover funds if possible. Yep, we will be selling your stuff for pennies on the dollar or simply disposing of the stuff of no value at the local garbage dump 31 days later. This does not comply with the statute, and in fact, it just appears that the landlord is using the items as hostage, and from that it appears to me that the landlord indicates any money or I should say the landlord indicates that for the tenant to obtain the property that they're holding, that they have to pay the rent and the total debt owed, and that definitely does not comply with the statute. And that's why I put in the slide that the contents are being held hostage for the rent. And again, that is wrongful. In any event, this is the notice that the landlord gave to the tenant prior to the expiration of the statutory notice period. So now we'll proceed to the interesting court commissioner ruling and what she said during the hearing, which to me is even more interesting.
Okay, so now we're looking at example number 2, the commissioner ruling. Now, of course, this entry does not always include everything the commissioner said. That's why they at least in Snohomish County, they record the commissioner hearings. During the hearing, the court commissioner flat out rejected the tenant's assertion that the notice that was given by the landlord affects the notice, the statutory notice. And what the commissioner said was that the tenant could have called the sheriff to find out if the information in that note was true, or the tenant could have gone to the county recorder's office and gone through the records to determine that in fact nothing had been recorded with the county, or the tenant could have gone to court to find out if a court order was entered. Frankly, the position of the commissioner is outrageous, and it's not correct. And in fact, just to fast forward to the conclusion, after this order was entered, the plaintiff's attorney realized the horrible situation they were in, realized how ridiculous the court's order was, and the plaintiff then took a voluntary non-suit. So what happened was, first off, the defendant brought a motion to dismiss this because of lack of subject matter jurisdiction, which at the time was the case law that this court was bound to follow, that if the notice was improper, that the court did not have subject matter jurisdiction. And the basis for moving to have it dismissed was that the notice given by the tenant trumped what was stated in the notice, because basically the tenant was said, it doesn't really matter if you pay the rent or you respond now, because we've already gone to court. So then the court orders the defendant to pay $2,590 into the court registry by the 15th of August. Interestingly, the court never dated it, so I can't really tell you without looking at the court record how many days the tenant was given. But there is no statutory authority for this. There's no statutory authority that I know of, and the court never cited an authority for that. Most likely is just the rule. I'm sure you've experienced that. You go to court and the commissioner will make a ruling based on the rule. They'll never tell you what the rule is. It's just some rule. Additionally, it says the plaintiff shall be entitled to a writ of restitution without notice and upon payment of a $10,000 bond if the tenant does not timely, I guess it continues on the next page, but there's also no authority for the plaintiff having to post the bond. In fact, specifically, when you take a writ to the sheriff, typically you put on there that no bond shall be required. Otherwise, the sheriff may require a bond. This appears to mean some type of bond to the court. It's just difficult to tell. In any event, so the $10,000 bond is required if the tenant does not timely make this payment. Again, I have no idea what the statutory authority is for that. Just reviewing a little bit ahead, it appears that the notice was signed on the 13th, and so the 13th of August. So the tenant was given 2 days to come up with $2,590, which is not a whole lot of time. The one saving grace in this matter was that the court did not condition a trial upon the tenant paying the rent that the landlord claimed was due. That does happen many times with the court commissioner, particularly in Snohomish County, where they will request that the tenant pay the disputed amount of rent before they're entitled to a trial, and that is not correct.
a trial cannot be conditioned upon payment of rent or payment of some amount into the court registry. If there's an issue of material fact, the tenant is entitled to a trial. In any event, as I stated previously, the landlord's counsel realized the ridiculousness of the situation, and the landlord's counsel was also shocked at the existence of that note. Most likely he would not have set a show cause hearing or even proceeded forward with this matter had he known that that note existed. And that's a good practice pointer, is make sure you have everything from your client, because things like this pop up all of the time, and you can see it just by looking at the face of the plaintiff's attorney, and sometimes on the landlord's attorney, when the tenant changes some fact or throws out something that you had no idea existed. I do have one last comment on the preceding slide, which I forgot to address, and that is the trial is for material issues of fact, not legal findings. In this matter, the court commissioner set this matter for trial on an expedited basis, which is proper, to determine whether the July 19th, 2008 writing invalidated the 3-day notice that was delivered on July 17th. That's curious, because that's really not a material issue of fact. That's an issue of law that a court commissioner should be able to rule upon. It just doesn't appear that there would be a factual determination that could be resolved at trial. And again, that's probably the reason why the landlord's attorney took a voluntary dismissal in this action. So now, if you would turn to what is example 3, which is a 3-day notice and a portion of the lease. I'll give you just a moment to review that notice before we go forward. Okay, so right now we're looking at example number 3, the 3-day notice. The important thing to note from looking at this notice is the manner of service. So if you look at the bottom of the notice, you will see that the box is checked off by stating that the process server knocked on the door, which is proper, after there was no notice, or there was no answer, by posting a copy in a conspicuous place on the premise and mailing a copy to each party named on the 3-day notice. That appears to be proper. It only leaves open the question of which county the notice was mailed in. But again, that's something that could be testified to by the process server. So everything appears to be in order once you look at the 3-day notice. So I guess it's time to review the lease. So I hope you've had time to review the lease. So what I've said is previously, it's real important to compare the statutory notice, which in this case was a 3-day notice, with the lease agreement. The statutory notice at the bottom part of the declaration states that they attempted personal service, they were unsuccessful, so what they did was they posted and mailed a copy of the notice. That's perfectly fine under RCW 59.12.030 and 040. Perfectly fine notice. However, if you look at paragraph 8 of the lease agreement, it says that it goes over the method of service. That any violation of this agreement shall be sufficient cause for an eviction from the premises upon 3 days written notice thereof by registered mail or by personal service. Well, we know from reading the declaration they could not accomplish personal service. So in this situation, the lease agreement supersedes the statute. The statute requires service by mail, and this eviction notice, or this lease requires service by registered mail. Now, in this matter, in fact, the tenant received the letter via regular mail, not registered mail. So under the Community Investments v. Safeway case, when a lease agreement has provisions that allow for longer time periods or more severe constraints than anticipated by the statute, you have to go by the lease agreement. That authority that the lease agreement would supersede the statute was also re-emphasized in the case of IBF LLC v. Huft, and that was a Snohomish County case. Interestingly, in this matter, the court actually did hold that service by regular mail was adequate, and the court basically stated that it was not necessary to serve the notice by registered mail as required in the lease agreement. And of course, you must understand that there's no certainty anytime you make an appeal, and the cost of the appeal could have devastated the tenant, and I believe a decision was made by the tenant not to take the risk of losing upon appeal because there was really no upside and a tremendous downside. But in any event, based on the unpublished opinion Culpepper v. Jordan concerning proper service, it's most likely that had this been appealed, that the trial court would have been reversed and that the eviction would have been improper. If you could now look at example 4, and on example 4 there is only a 3-day notice, and I will give you a brief opportunity to review this notice before proceeding.
hope you've had enough time to review this notice. If you're listening to the recorded version, just hit pause if you want more time to review it. And if you're listening to this in the live version, there will be time for questions at the end if you have any questions on it. Basically, there really are no problems with this notice. The address appears to be correct. You've got past rent. You've got current rent due. There's no unusual fees included anywhere on the notice. Of course, you can't see all of the signature line because the business card of the attorney that prepared the notice was attached to the notice, and in fact it was also noted to the right that this attorney was also the attorney for the landlord. As I noted previously, when a landlord prepares statutory notices, there is no requirement. There are no requirements under the Fair Debt Collection Practices Act. However, if a debt collector, which case law dictates that an attorney is if they're collecting past due rent, then certain notices must be included on the statutory notice. Basically, there's a notice that the tenant has a right to have the debt validated. In this situation, Landlord's Counsel set himself up for a FDCPA claim, which in fact did happen, and that matter was settled. But it's interesting that the business card was stapled right to the notice to prove some of the elements necessary for an FDCPA claim. Now we're ready to review example 5, and there are two documents in example 5, a 3-day notice and an excerpt from the lease agreement. Please review those and then we'll go over them. Okay, I hope you've had enough time to review the lease agreement and the statutory notice. The first thing I want to point out is that the statutory notice was prepared by an attorney. As you can see on the signature line it says Michael Cullen, attorney for IBF LLC. This does not, however, subject the attorney for liability under the Fair Debt Collection Practices Act because that is for consumer debt, not debt owed to a business. So in this matter, Carmen Huft ran a beauty salon at 2228 Colby Avenue, so there would be no liability under the FDCPA. If you look at this notice, at the top it says it's a 3-day notice to pay rent or quit the premise. So now what we need to do, as I stated before, compare the notice to the lease agreement, so now we need to look at the lease agreement. In the lease agreement, if you, let me just locate the section. Okay, if you look at section 18, paragraph 18.1, or actually it's 18.1 paragraph B, failure by the tenant to make any payment required as and when due, where the failure shall continue for a period of 10 days after written notice by the landlord. In this matter, the landlord prepared a 3-day notice, which deceived the tenant as to the tenant's rights under the lease agreement. And in fact, the landlord filed the action 9 days after service of the 3-day notice. In any event, the argument was made that given the time frames before the eviction took place, it actually more than 10 days had expired, and this went to the Court of Appeals. The Court of Appeals didn't buy it, but in this matter, it was pointed out to the court commissioner that the lease agreement required 10 days notice before the eviction action could begin. Thus, it was premature, and the court commissioner actually refused to review the lease. She believed that you had to go by the statute, which was directly contradictory to case law. So now there are at least 2 cases that stand for the proposition that when the requirements in a lease agreement are stricter than the statutory requirements, that you must follow the stricter you must follow the stricter lease requirements. And those 2 cases are IBF LLC v. Huft and Community Investments v. Safeway. The next document we're reviewing is example 6, which is a 3-day notice. Please take a few moments to review that, and we will go over it. Again, I hope we've had ample opportunity to review Exhibit 6. And the only real interesting thing that could be noted from this is that this is a 3-day notice for payment of rent, but they have utility bills for January of $166.90. So presumably, had the tenant paid just the rent, the landlord still may have gone forward based on the utility payment. However, as we discussed previously, the 3-day notice is for rent. The utility notice should properly be under a 10-day notice. Now, there have been at least one unpublished case that said you can have these additional fees attached with a 3-day notice. But the reason for this CLE is to put you on notice as to proper procedures so you can keep your client's costs to a minimum, or if you're a landlord, so you can do it properly. And $166 isn't very much when you compare it to the cost of having an attorney argue this matter before a commissioner, a judge, or the Court of Appeals. If it went all the way to the Court of Appeals, your costs could end up being anywhere between $15,000 and $25,000. So there really should be no problem with just doing it right, which is not to include utility bills on a 3-day notice. So now we're to our final example, and that's example 7. So if you could please open example 7 and review it. I'll give you just a few moments. Okay, I hope you've had enough time to review example 7. This is just going to be a 3-day, a declaration for service of a 3-day notice. The first thing that you should notice from this declaration is that it was prepared by an attorney. You would suspect that the attorney would review everything to ensure that it was properly prepared and served. And in fact, it appears that the attorney did do this in the matter. He just had a different interpretation of the statute than the Court of Appeals, although the court commissioner twice and a judge twice agreed with his understanding of proper service of a notice. But if you look at the notice or the declaration, it does show that the notice was only delivered to one of the 2 tenants, and further, that the second tenant, being the wife, did not receive a copy by mail. And as stated above, under the section of notices, if you don't personally serve both the husband and wife, you at least need to hand a copy to the person you do serve, or post a copy on the door and mail a copy to the party that you were unable to personally serve. Also, if you take a look at the notice, it includes a deposit that allegedly was not paid by the tenant, and that's attached to the declaration is a copy of the actual 3-day notice. It lists a $400 deposit, a $200 pet deposit, 6 months of late fees in addition to the rent. And again, as discussed previously, deposits, late fees, other items related to lease conditions other than rent payment should not be included in a 3-day notice. So this should have properly been included in a 10-day notice. It is also interesting to note, a little bit off topic, but they included April's rent of $700 and March's rent of $1,300. It makes it a lot easier to determine rent owed if you have clients or if you're a landlord to account this way, and that is to apply all rent payments to the oldest owed amount. So if a tenant doesn't pay March's rent,
And then on April 1st, if they would have paid, say, $1,300 in this matter, instead of applying that $1,300 to April's rent, it should appropriately be applied to March's rent, and then just wait the statutory period in April before serving and initiating an unlawful detainer action. So legitimately, unless the lease would dictate otherwise, what this notice should have said was March's rent was, there was $700 owed, and April's rent there was $1,300 owed, and it would not have had the 6 month of late fees, the pet deposit, or the other deposit. A good pointer would be to ensure that your clients, or if you're a landlord, that your leases state that all payments that are made will apply first towards late fees and then the oldest month's rent. What this does is it allows you to serve a 3-day notice without having to worry about the late fees for the prior months, because any payment would apply towards those late fees first. And legitimately, a late fee should be a 10-day notice for failure to comply with a condition of the lease. And so that this, for ease of calculation and to reduce the number of days you would have to wait, service of a 3-day notice only for the current month's rent would make sense. Alternatively, what this landlord could have done would have been to serve a 3-day notice for March and April's rent, and then serve a separate 10-day notice for the late fees, the pet deposit, and the deposit. But there again, the action could not be filed until the 10-day notice period plus any mailing days, if appropriate, had expired, so it would slow the eviction down by 1 week.
We will now move on to practice forms. Please open the sample 3-day, 10-day, and 20-day notices. The next screen will include some or all of the information that you will need to complete the form. Please pull out the information and fill in the correct blanks. The reason that I say some or all is that there may be missing information, and there is some information that you will not need. To make things easier for you, I will give you this hint. Some cities in Washington are in 2 counties. Bothell is one of those cities. In Bothell, if there is a north in the address, it indicates that it lies in King County. If there is a south in the address, it indicates that it is in Snohomish County. This is critical, as jurisdiction in an unlawful detainer matter is granted to the superior court in the county where the property is located. If you file a matter in the wrong county, the court does not have jurisdiction. The court commissioner might not catch this error, but the sheriff will. In all cities, the city police do not handle unlawful detainer matters. It's always the county sheriff. If this confuses you, don't worry. Even the Bothell police don't always get it right. One defendant in a Bothell criminal matter had his case dismissed because the police got a search warrant that listed the county, or listed the property as being in King County, but the property was actually located in Snohomish County. To complicate things, a Snohomish County judge signed a search warrant authorizing a King County address to be searched. By now you should have opened up the sample or the blank 3-day, 10-day, and 20-day notice sheets. I have also included what I believe to be the properly completed notice forms, and we will go over those later. If you were listening to the recorded version, you can hit pause at any time if you want additional time to complete these, but I will allow about 5 to 6 minutes for you to complete these for the live seminar before we start going over the answers. I'll just quickly read over the information. The landlord's name is John Smith. He lives at 3412 Geronimo Lane in Seattle, Washington. His zip code is 98148. His phone number is 206-388-4755. The tenants' names are Mary Johnson and Bill Jones. They live at 9606 Northeast 204th Place, Bothell, Washington. The zip code is 98011. Their phone number is 206-455-2424. Their monthly rent is $500, and they have failed to pay all of July of 2013's rent, and they have failed to pay $265 from June's rent. The landlord wants $35 in late fees for June, and they failed to pay $400 of their $1,000 damage deposit. Today is July 15th, 2013, and the landlord desires that a 3-day notice for rent, a 10-day notice for failure to pay the late fees and the damage deposit, the complete damage deposit, and a 20-day notice to terminate the tenancy to be served today, so that the tenant can be evicted as soon as possible on each of the notices. There is a written month-to-month lease agreement that requires a $1,000 damage deposit, but it includes no late fees.
Okay, that should have been enough time to complete the notices. If not, and you're taking the recorded version, just hit pause. And if you're on the live version, you'll have plenty of time later on to review what you've done and compare it to the recommended copies that I have completed. So first off, let's take a look at the 3-day notice to pay rent or quit premises. First off, if you know, we have the full name of both tenants. Now, if it was Mary Johnson and Bill Johnson instead of Bill Jones, I would do it just that way, Mary Johnson and Bill Johnson, not Mary and Bill Johnson. And that's just for consistency on the complaint. The whole idea behind notices and every action you take in an unlawful detainer action is to get rid of any gray areas or any inconsistencies, which can only work to the advantage of the tenant. If you'll notice, I put the county is King County, as we discussed earlier. Now, in the situation I described in the city of Bothell, you can just look at the address, and if the address has south in it, then you know it's in Snohomish County. If it has north in the address, you know it's King County. But in other cities that straddle county lines, the best thing to do is to Google the address. And this works out for many reasons, not just jurisdictional reasons. Very often, a landlord will give you a wrong county or a wrong street address, and if you look it up in Google, you can get the correct information. I've actually seen examples where the title reports have had the wrong address or utilities have had the wrong address. And it could be something as simple as, it could be, in this example, Northeast 204th Place. The landlord could have given you the address 204th Place Northeast, and that could cause a problem with the sheriff. The next thing is, if you take a look there under number A, balance summary, we put the month and the year for the current rent that is owed, which is $500, and then we put all of the prior months combined. As I stated earlier, there should be nothing under miscellaneous, no late charges due to gray areas in case law. You then total that up under number E, and then if you look to the 10 o'clock position of number E, you'll see another blank where you would put the summary total in up above. And then just to the left of number E, you see where we put the monthly rental amount. That's not necessary, but it's a good idea just to have it on the form so everybody knows what the rental is. And when you later go to prepare any subsequent notices, it's an easy place to locate the monthly rental amount. Now going down a little bit further, if you look under the landlord's name, there is an actual street address instead of a post office box. That's another gray area that only works to the benefit of the tenant, because the tenant could argue that, oh, I went to the P.O. box at 10 o'clock on the last day and there was nobody there to take the rent. Well, of course not. It's a P.O. box or a mail service. So it's always best to have a physical address just so that you can eliminate that objection. Now, just take a quick look down the declaration. I want to point something out. Okay. What I'm trying to point out is that it does say that which county you mailed the document in. This would be crucial in a matter such as this one, where the tenant's street address is, and actually I picked out this house address of 9606 Northeast 204th Place for a specific reason, and that is this residence is about 300 feet from the county line. So you couldn't just leave this and drive north a couple blocks and see a post office box and put it in that box. That would not be the correct county. So from this address, because it's in King County, you would have to drive somewhere south and deposit the mail in a post office box in King County. So it's not going to happen very often, but it could be fatal to the eviction action. So now if we could take a look at the 10-day notice, which is just, it's not titled 10-day notice, but if you look at in the wording inside, it says you have 10 days after service of this notice to comply. On this notice, basically the name and address information is the same as previously. About a third of the way down the page, you'll see where it says See Exhibit A. It's a very good idea to attach the lease agreement there. That way there can be no questions as to what the lease agreement is. And I believe we talked about this previously. Now, if you look at the violation, it says failure to pay $400 of the $1,000 damage deposit as required under paragraph 8 of the lease. Of course, you would need a lease in front of you to determine what paragraph it was, but it's very specific. And sometimes in the law we search for brevity, but in a situation like this, it's best to explain it as well as you can and take whatever amount of words it takes so that there can be no question in the tenant's mind exactly what they have violated and what you are requesting them to do. So the next notice then would be the 20-day notice, and it's titled 20-day notice to terminate tenancy. Now, if you take a look at this, the notice is signed on July 15th. The 20 days must end at the end of a lease term. In this situation, the lease is month to month, so it would be at the end of the monthly period. Occasionally there will be circumstances, such in the cases of Leda v. Wisnan, where it appears that there was a lease period that was something other than the end of the month. So, although the notice was signed on July 15th, the termination notice can only be effective at the end of a lease period. You could not terminate the tenancy on July 30th. How about July 31st? You cannot terminate it on July 31st, the last day of the month, because that would only be 16 days after this notice. You also could not terminate it on August 4th, which is 20 days after the notice date, because that's not the end of the lease term. And this is a fairly common mistake that both landlords and attorneys representing landlords make. They believe that a 20-day notice to terminate can take place at any time. Now, another rule of thumb that attorneys use is that attorneys and landlords is a 20-day notice has to be served by the 10th of the month. Well, that works in some circumstances, but one of the problems that arises is, what if the tenant is not there? Then you have to give 20 days plus 1 day notice, or a total of 21 days notice. So if there's 31 days in the month, you're in great shape. But if there's only 30 days in the month, you have to serve the notice. If it's not personally served on all the tenants, you have to serve the notice by the 9th of the month. Now, the other two exceptions would be leap years, February 29th, or other years where there's 28 days in February. In those circumstances, the notice would have to be served by February 7th or February 8th, depending on whether or not it was a leap year. So it's real important to make sure you count the number of days, and you would be amazed at the number of landlords who call you on the 9th or 10th of the month knowing they've got 20 days, and you could literally get a call as you're walking out of the door about 5 p.m. on your office on the 9th, and the tenant thinks that, or the landlord thinks you have one more day to serve the notice, but in actuality, you've got to get it served that night. It happens very frequently. So, I have no other comments on the rest of the 20-day notice, and so that will end this CLE. We're just going to briefly go over our goals to ensure that we met all of those goals. And again, I would like to refer you to the website of www.washingtonevictionattorney.com if you'd like to get any forms or any advice. There should be a link for an attorney there who could answer any questions you may have, or if you want to refer a case. He's one of the better attorneys in Western Washington as far as unlawful detainer actions. Well, again, I want to thank you very much for listening to this CLE. And if you have any questions or concerns, just go to the webpage, www.lowcostcle.com, and you can learn about upcoming seminars and either recorded CLEs or live CLEs that we will be having. Our goal on all of these CLEs is to have the lowest price out there. While the Washington State Bar Association, some of the local bar associations, charge up to $100 for a credit hour of CLEs, we are trying to keep our prices considerably lower than those prices. So now let's just quickly review our goals for today's CLE. First, we've learned about the significance of proper notice. Under the United States Constitution, along with our state constitutions, notice with an opportunity to be heard is necessary as a due process element for summary proceedings that deprive a person of a property right. Second, we learned how to properly prepare the notices. Again, special thanks to WashingtonEvictionAttorney.com for the sample eviction notices on its webpage. And third, we went over some of the common pitfalls that an attorney faces. And we specifically went over those pitfalls on a 3-day, 10-day, and a 20-day notice. Thank you very much for listening to today's CLE, and I hope you come back and watch and listen to more of our CLEs. Thank you very much. Initial production of this CLE took place in Toronto, Canada in July of 2003. Thank you.